Okay, good morning everyone and welcome to Wednesday morning's seminar. I'm joined by Conor Ahern, consultant solicitor, with the latest in his QS series. Today he will be covering variations and happy to answer your questions. As always, if you can use the Q&A panel tool in the toolbar, the Q&A facility to ask any questions, and Conor will address all of these at the end. Also, if you have anything specific that you wanted to ask Conor but don't want to do it in an open forum, please feel free to email him, conor@silverllp.com, and his contact details will be in the slides. Right, without any further ado, Conor, I'll hand over to you.
Great, thanks very much, Julie. Good morning, everyone. You're all very welcome to this webinar where we're going to look at variations as part of the QS series. And yeah, we're going to get stuck into what it is variations are, basically what you need to know is how do you get paid for them. Okay, that's a bit of my profile. Yeah, as Julie said, just questions in the chat box, and we'll pick them up at the end. And obviously, this is more educational rather than legal advice. So please do bear that in mind. Okay, so yeah, we're going to look at background definition of variations. Going to look at what does your contract say. Emphasize the importance of your contract in relation to the variations, because that's where the entitlement comes from. Going to look at what I call variation categories, which is I find it's an easier way to define what they are, and it may also help you in your understanding of them. Look at valuation rules, presentation, before wrapping up there this morning. Okay, so background. So why do contracts include variation clauses? Okay, so variation clauses allow for changes which without voiding the contract. They give the employer the power to order varied work or additional work that may not have been required at the beginning of the project, and for various reasons employers change their minds on projects. It happens very frequently, and you need a variation clause to deal with that. It ensures the contractor is entitled to be paid for the additional work, which is obviously a key requirement for the contractor. It ensures the contract is not frustrated if it becomes impossible to carry out the contract work. It also sets out the rules for valuation and avoiding quantum merit type arguments. So quantum merit is basically where you're entitled to a fair and reasonable assessment of your reasonable cost expended. You can see that's even quite woolly wording, and it's quite difficult to actually deal with what that actually means. So hence the reason why we have variation clauses. When we say variations, we also mean a change to the contract works, which is instructed by the architect or contract administrator or the employer. We're going to today we're focusing on variations, what we call under the contract, so they're catered for in the contract itself. We can also have variations to the contract, and the best example of these is a deed of variation. So that's where you actually enter into a new agreement which subsists alongside your original contract. That's a variation to the original contract. But as I said, today we're focusing on variations under the contract. What does a contract say? Does a contract clearly set out the common intention of the parties when the contract is formed? There are significant differences between the standard form approaches, such as design and build, remeasurement, and lump sum. Obviously, depending on which of those options your contract is, will have a bearing on whether you're entitled to additional money for your variations. I mean, for example, lump sum traditionally means that that's a fixed price to carry out all of the work, whereas the remeasurement type contract does allow more flexibility for items which may, for picking up variations that may not have been identified in the original contract information. Okay, so the contract interpretation. So this is subject to the current rules of interpretation, which have been developed in the key case of Ahern versus Britain. And there are 6 requirements here. So the court's interpretation is that, so first you got to give the natural, you got to look at the natural and ordinary meaning of the clause. 2 is you got to look at any other relevant provisions of the agreement. 3, you got to look at the overall purpose of the clause and the agreement. 4, you got to look at the facts and circumstances known or assumed by the parties at the time that the document was executed. key point at the time the document was executed. It's not what their current knowledge is, it was what their knowledge was at the time they signed the contract. You got to look at commercial common sense, but you have to disregard subjective evidence of any party's intentions. So there's the, that's a very it's a real summary of where the courts are with the interpretation of the contract, which is important for assessing grounds for variations. General rule is handwritten over typewritten over print. So that means if the parties have made handwritten amendments, it's key that that shows that the parties have focused their minds on the points and made it clear that they are so important that they need to be actually handwritten into the contract. The typewritten is typically your schedule of amendments or such other document that would subsist alongside your print. When we say print, we talk about the standard form position, your JCT yellow book contracts, essentially. So that's it on contract interpretation. So document is to be read as a whole. Most contracts confirm that the document is to be read as a whole. For example, the JCT Design and Build 2016, clause 1.3. This is a position that is generous to the contractor, as if schedule of clarifications has been included in the contractor's price, then effect will be given to the schedule. Schedules like this are generally included so as to set out the contractor's intention at the time of contract, and then use this to demonstrate variations during the contract. That schedule of clarifications was a key, always a key document as part of a contractor's bid, because essentially it was, clarifying what position he took on areas where the information may not have been entirely complete, which has basically formed the basis of the price. And when you have a schedule of clarifications, it's a good starting point to state what your contract intention was, and then obviously as the information develops and the information changes, then it's clear what your original position was and what the actual construction, I suppose, position is, and you're looking for a variation for the difference between the two, essentially. A very key document. The document to be read as a whole is very important as well, because you don't have to get caught up in the hierarchy position, because often in schedules of amendments, it will say that the contract is to be interpreted under a certain hierarchy, and very often a contractor schedule of clarifications will be very low down the pecking order if it has been included at all. This is the hierarchy clause. So if the contract contains a hierarchy clause, then the interpretation ought to be in accordance with that clause. This position that benefits the employer, as this will work to ensure contract interpretation as the employer's requirement documents at the top of the hierarchy. The contractor schedule amendments will be of low priority if it's been included at all. In the event of a conflict, the contract will be construed in order of the hierarchy. So do watch out for that hierarchy position. It is important and very relevant to the interpretation of your contract. Okay, what if the contract is silent? So this is kind of a well-known case, a lump sum contract. So this is Thorne versus the Mayor and Commonalty of London. This is back in 1876. So the contractor provided a lump sum back then to build Blackfriars Bridge. The method of construction described by the employer was unsuitable, but the contractor was not granted relief. This remains a position in English law and serves as a reminder to contractors to clarify their risk under the contract. So very, very strict interpretation of what a lump sum was then, and obviously very harsh for the contractor. But he hadn't reserved his position on any of this, and it serves as a warning that contractors, you've got to be very careful in clarifying what risk you're actually signing up to in your contract. What if the contract is silent? So generally, when the contract is silent, we're looking at the reasonable or experienced contractor test, which is common in ICE, NEC, and FIDIC forms, which brings in issues around what is reasonably foreseeable at the time of contract. So a couple of examples here where variations occurred that were not reasonably foreseeable by a reasonable experienced contractor. So Barton versus Stiff. So there happened to be a high presence of salt water which penetrated brickwork, and ultimately the joints failed and had to be redone. the court decided that was not reasonably foreseeable, and the contractor was entitled to his variation. Next one is Bacall versus Northampton Development Corporation. Here, the employer gave an implied warranty that the ground was a mixture of sand and clay. When the ground turned out to be different, the contractor was given a variation. Most contracts now say that the employer does not warrant the information provided as a result. That's very common, because if the contractor isn't warranting the information provided, then if the employer isn't warranting the information, then the contractor is going to struggle to rely on its accuracy. And if the actual conditions turn out to be different, then the employer has basically absolved himself of responsibility and said, well, I didn't warrant the information, and therefore I'm not responsible. So that's a common type of argument that seems to be happening at the moment. The reasonable experience contractor test continued, but here's where the variation was not approved. Okay, so in the case of Van Oord versus Allseas, the site investigations were limited. Areas not tested were significantly different to those that were tested. The experienced contractor should have foreseen this. So there you have an example. I mean, I used to work I used to be QS for a groundworks company, and you'd always be like, most important document you were being provided with was a site investigation report. You had to look at that in a lot of detail. If areas of the site had not been tested, or if the boreholes were, not suitable or insufficient for that particular site, you got to raise that point, because you're going to be taking, if you don't, you're going to be taking the risk for those areas that have not been checked, and ultimately that's where you're going to encounter problems. Obviously, ground conditions has always been a hotbed for contention, and that doesn't seem to be going away anytime soon. Obrascon versus the Attorney General of Gibraltar. So here the site was previously used for military activities. The contractor had not addressed the position on contamination in the contract. It was reasonably foreseeable that the contractor should have referred to the contamination in his contract. So again, you got to look at what's obvious. I mean, for example, if you're working on a former petrol station, if you don't raise any issues around contamination, then it's going to be difficult for you to pick up variations afterwards. I mean, absolutely, these points are key to managing your risk, and then allowing you to seek your variations during the construction phase. Okay, other key considerations here is the entire agreement clauses which limit the opportunity to bring in any pre-contract correspondence unless it has actually been included in the contract. So you got to watch that if you have an entire agreement clause and any of let's just say important information is in emails. If those emails are not listed as contract documents, then you will, generally will not be able to rely on them. So you got to be very careful with that. The employer's requirements and the contractor's proposals, you could probably do on these two grounds alone. It's such a big area. You see a lot of employers want the employer's requirements to become the contractor's proposals, and basically have the contractor take on the risk for everything that was in the ERs at the time of contract and then to completion. Very common area that we have to review as solicitors to advise on the risk and come up with ways for managing this. But it's something that you got to be very vigilant on when at the time of contract. Conditions precedent and the requirement for notice within a period of time, as with NEC. That's obviously key to getting your variations, as well as that you've actually given your notice. If you fail to give your notice, then you won't have any entitlements. That's the position in English law, and absolutely NEC is very, obviously all the NEC contracts include notice periods, and it's very common with JCT through their schedules of amendments that notice of delay must be given with a specified time also. Finally, a notice, watch out for no oral modification clauses, which is ROC advertising versus MWB. So no oral modification means that the parties cannot modify the contract orally between them. Any potential modifications must be carried out in writing, and notified, obviously, and agreed between the two parties. So that's it. So the conclusion to this area is that most variations are actually written into the contract before the QS receives it. For the QS, it's key to understand the structure of the contract. It's very important to check where does the schedule of clarification sit. Variations are one of the key reasons why contracts do not get executed, because variations can happen very early in a project, and I've seen it where, as a reason for that, neither party wants to take liability, and as a result, it is actually the reason why it doesn't get signed. Parties continue on a letter of intent, or basically it leads to this position called the Battle of the Forms, which is a complex and difficult argument to resolve, and should be avoided at all counts, because it's very difficult, and they're quite, as I said, they're complex type arguments. So yeah, you can see the importance of variations. But that top point, I think, is actually the most important. I mean, that they're actually written, your variations are pretty much written before the QS receives it. And what this should do is encourage some form of engagement by the QS as part of the tender process, if at all possible. If you can actually move between the two, you'll have a better chance of a successful commercial outcome at the end of your project. Okay. Right, moving on to these categories of variations, and the grounds I'm looking at are based on JCT contracts. The NEC wording or FIDIC type contracts, they're all quite similar. So if you can understand the principle, you'll be able to apply it to whatever contract it is you're working with. So category 1, so this is the alteration or modification of the design, the quality or quantity of works, which includes the addition, omission, or substitution of any work, the alteration of the kind or standard of any of the materials or goods to be used in the works, and the removal from the site of any works executed or site materials other than work, good material or goods which are not in accordance with the contract. So you're looking at the design changes, the quality, that's generally a specification change. Quantity, obviously, I mean, that's more applicable if you have a remeasurement contract, obviously. I mean, if you're under a lump sum and you've taken the risk on quants, then it's less likely, there's less application there. Okay, so additions and omissions. So it usually becomes a schedule and evaluation and tracks adds and omits between the contract and construction information. The quantities are amended, but the rates remain the same unless restrictions are imposed in line with category 2. So the same rates will apply. You have a bill of quants. The same rates will apply to that varied work, to that additional, to the work that's either been added or omitted, unless there are changes in the conditions, which we'll look at. Omissions. So key point to remember on omissions, it's controversial and are subject to limits as established in the case of Abbey Developments versus PP Brickwork. That was back in 2003. So omission clauses are sensible if the development no longer becomes viable. I mean, if the project is no longer viable, for example, the employer runs out of money or the project just doesn't make sense anymore, then obviously the omissions clause makes sense. However, you got to clarify this. Clarify omissions, though. It's where contract works are omitted so that they can be carried out by at cheaper prices by another contractor. Well, that is not permitted. Judge Humphrey Lloyd confirmed that a contract for the execution of work confers on the contractor not only the duty to carry out the work, but the corresponding right to be able to complete the work which contracted to carry out. To take away or to vary the work is an intrusion into and an infringement of that right, and is a breach of contract. So that's the position, where you want to omit work and give it to another contractor at cheaper, at better rates. Basically, that's a breach of contract. This position was confirmed in a case earlier this year in Vanur UK versus Dragadas UK. So again, just confirming, you can't do that. But sometimes, I mean, go back to what it says in the contract. What, in Abbey Developments, what the judge is saying is that if the words are very clear, that says that, the employer may omit the brickwork and give to another contractor at some point. If wording like that has been included, then I mean the parties have focused their minds on to the point, and the contractor knows that work may be omitted, and he's given permission for that element of work to be omitted. If that has been the case, then that can work for the employer if that's what they want to do, but it has to be very clear in the contract of that. If not, it's going to be a breach all day, every day. So do watch out for that. Okay, category 2. So what we saw, we're talking about category 2 variations. We're talking about the imposition of an instruction from the architect or contract administrator of any obligations or restrictions in regard to access to the site or use of any specific part of it, limitation of working space, limitation of working hours, or the execution or completion of the work in any specific order. So it's like to changing the conditions in which you're carrying out the work. And generally that means that additional restrictions have been imposed upon you. So access to the site, so working space, well, access to the site, obviously, if the access changes, I mean, if they move, I mean, if the, just say the site welfare gets moved, you say that there was another site on, that they wanted to place the site cabins, a distance further away from what they originally intended. I mean, that's a variation because that's going to take site operatives longer to get to and from the welfare, which will result in reduced productivity. Working space, which involves working in close proximity to other trades, but most contracts state that the contractor shall not have exclusive use of the site for this reason. So if your working space does become more restricted, then you gotta look at that and see what does the contract say that may entitle you to a variation for it. Working hours usually become an issue in relation to Saturday working or local council restrictions on delivery hours and noisy working hours. I used to work in a lot of projects in Roy Borough of Kensington and Chelsea, and very often there were changes being made quite regularly to the noisy working hours. I mean, it would be very common that you start on site and you could have no restrictions. Once the work started and perhaps there were complaints going in from neighbours, that those working hours were changed, and particularly noisy working hours. Frequently, it happened that they'd be changed to be limited to any time between 10 o'clock and 12 o'clock, and then 2 o'clock and 4 o'clock. But obviously, that has an impact on productivity on site. Which, again, if you clarified in your, if it's clear in your contract that you're not working to any noisy working hours, then you will be entitled to a variation. So do watch out for that. So the execution of the works in any specific order, again, we're saying depending on the contract wording, if the contract is silent as to the order of works, then if the employer's team issues an instruction to complete the works in a reasonable order, then this will not always amount to a variation. Case here is Neodocs versus Swinton. And the engineer instructed the contractor to carry out work in a specific way. The court held that the contractor is entitled to a variation if the engineer's instructions amounted to a breach of contract by the engineer or the employer. In this case, the working method proposed by the engineer was reasonable. The instructions amounted to a variation over in addition to the contract works, for which the contract was entitled to an extra charge under the contract. But that was where the method proposed was unreasonable. In Neodocs versus Swinton, the engineers, because the contract didn't clarify the contractor's method, and the engineer instructed a reasonable way of doing it, which the contractor said was different, it wasn't automatically entitled to his variation. And hence, again, we keep coming back to the importance of the contract. So important to have your position clear in the contract as to your method of working and how you actually intend to carry out the works. Okay, the right to object. So the contractor has a reasonable right to object. Relates to what I was saying about the category 2 variations, which is generally under clause 3.5 on JCT contracts. Typical examples would include works outside the contract. For example, asking a ground worker to carry out painting works. I mean, obviously, it is it's absolutely right that the groundwork contractor would be entitled to basically object to carrying out the painting works because it's just not within his remit to do so, or not in his interest, or indeed most of the ground workers I know, it wouldn't be in the interest of the employer to have them carrying out the work either. Changing the access to the site again. Again, that's a change in the conditions, like I was saying. So yeah, lack of agreement on price is not sufficient, and the fact that there is an error in the bill of quantities rate is not a reasonable objection. So the right to object, it is limited, and it relates to the imposition of any additional restrictions on the and absolutely you should raise the objection if you think that that it is going to have an impact. I mean, and if the employer says to proceed, then they know that they're going to be looking for the variation. So either way, you're covered. And it's absolutely the right thing to do. That kind of early engagement and the early notice to the employer is always good practice for contractors to get into. The valuation rules. Okay. So where the execution of additional or substituted work is of similar character, conditions, and quantity, priced at rates and prices in bill of quants or the contract sum analysis. So that's where the similar character, conditions, and quantity. Then you're just going to use the bill rates. That's that's one of the real benefits of having a bill in these circumstances. So if the work is of similar character, but there's different conditions or quantities, then a fair allowance must be made for the difference. So just say the employer imposes a restriction on the contractor that which changes the conditions in which the work is to be carried out. I mean, then the contractor really, he's got to look at his original bill of quants rate, and then he's got to look at what elements have actually changed here. Is it that I'm using? Is it taking my labor, my men longer? Do I need more plant to carry it out, or do I need more materials? And basically, what you got to do is go in and just basically uplift those affected areas. It doesn't mean that you can go back to to building up a new rate. You should start with the bill rate and then adjust that accordingly. Or where the work is not similar to rates and prices, then the valuation must include fair rates and prices. So that's where you go back to perhaps providing invoices as to cost, or and then just building up a rate basically to reflect the actual work that's been requested. The valuation rules, so similar character but different conditions, states that a fair allowance for the change in conditions must be included. So this was dealt with, what's a fair allowance mean? It was dealt with in the case of Henry Boot versus Alstom Combined Cycles. And it held it to mean that a fair valuation generally means valuation which will not give the contractor more than his actual costs reasonably and necessarily incurred, but similar allowances for overheads and profit. For anything more would confer on him an additional margin for profit and would not be fair to the employer. It's actually quite similar wording to the general rule that we have in loss and expense type claims, where basically where you need to put the contractor back in the position he would have been in if the contract had been performed. Similar type position, he's saying that it's a fair valuation, you're entitled to overhead and profit, but not over and above that which you are entitled to in the contract. Because if it is anything more than that, then it's unfair on the employer. And it's a sensible ground on which to approach the valuation of your variations. Valuation rules then was dealt with in Weldon Plant versus the Commission for New Towns. And this also dealt with the point that a fair valuation to be made that excluded an allowance for overheads on the basis that the contractor had to establish that it either occurred additional overheads or that it was denied overhead recovery. The court held that a fair valuation had to include an element of account of profit in the absence of special circumstances. So that's sort of saying you're entitled to a fair allowance for your overhead and for your profit also, which is absolutely sensible. You can't complain with that, and is a fair position. Okay, so other key considerations in this area. So what happens if there is an error in the bill of quantities or the contract sum analysis? And then basically the employer instructs additional work under that rate, perhaps knowingly or perhaps unknowingly. what is the position for the contractor? Does he have to carry out that work? So you receive an instruction to carry out additional works to receive an instruction to carry out additional work under this rate. Again, this is looked at in Henry Boot versus Audit Compliance Cycles. I mean, it's a contractual rate, and as such, contractual effect is given to it. So if there is an error there, then the contractor will, in most circumstances, be required to carry out the work for that rate. I mean, it sounds harsh. I mean, you can have a lot of discussion about, look at, how is the rate, was the rate how was the rate negotiated at the time of contract? You can look at any potential changes in conditions and the reason why. For example, if just say again, go back to groundworks example, if you had a rate in for taking material off site, so taking soil off site to a tip, say, you had a bill rate in. And for example, as we experienced about 5 years ago, when during a period of prolonged rainfall, the tipping facilities actually increased their rates. So, and on the same site, then the employer instructed the contractor to take away further material off site. Look at certain specific scenarios like that where we were able to negotiate a change to the rate given the background circumstance that were happening, and look at the the reasons why the tipping facilities were looking for an additional premium on the rates, and I suppose set out your case as to why it's unfair that the contractor has to take the risk and take the hit on such increases. It's just an example to work with, to where, look, at the end of the day, you got to look into these things, and if there are errors, you got to look at, obviously you understand why, how did that occur, but obviously look at, you're also trying to look at has there been a change in the conditions that will give you an uplift which makes it more commercially viable. If there is, you got to work on that and develop your case to give yourself a better chance of actually being able to receive your additional sums for that on that particular variation. Watch out for the position after practical completion also. As the architect contract administrator are unable to instruct after practical completion unless specifically provided for in the contract. The contractor should seek clear agreement before proceeding in order to ensure that they are paid. So yeah, just a warning there. I mean, like the architect and contract administrator's powers to instruct variations generally end at practical completion. So if you are still on site beyond practical completion, perhaps carrying out snagging works, perhaps taking material off site, perhaps back for a return visit for whatever reason, if you're asked to do variations, you just got to make sure that that it's acknowledged as a variation, so that you would be paid for it. Okay, so finally, look at presenting variations. So obviously the records are key. We'll just touch on this now. So obviously daily diaries are helpful. Obviously it depends on the quality of the information of the daily diaries. So I mean, QS has got to be, looking at those to make sure that that it's giving you the information that you need in order to help substantiate any variations as well. Progress reports are useful, so you can see where delays have occurred. You can look into that, have the conditions changed, have more restrictions being imposed, and use that as a way to demonstrate how you've been affected, and how you should be entitled to an uplift on your variation rate. Drop line programs, again, we're on about time, all of labor is all time related, plant is all time related, prelim is all time related, so important in relation to variations. As well as your loss and expense. I mean, it goes hand in hand with loss and expense, but it's also very, very important in relation to variations. So, you do generally get some good information for variations in your drop line programs also. Photographs are key, especially when demonstrating, what actually conditions were encountered on site. So, obviously very important to be taking regular photographs and to obviously be collating the other photographs from from the other members of the site team also. Email's key, obviously, it's what we all rely on when, unfortunately, later on when, if a dispute occurs, or if there's any if there's any challenges on whether there's variation entitlement or not, and obviously your notice as well, because the notice, you got to get the notice right in under the contract in order to get you off the ground to get the variation also. So do watch out for that. Allocation sheets, very good resource if you can do them. It's absolutely great function for any kind of trainee QSs to be familiar with allocation sheets, and to be just to develop awareness of how long it takes guys to carry out different tasks. Brilliant kind of learning curve, and brilliant development of site experience through allocation sheets. And if there is any trainee QSs should definitely take the opportunity to have a look at those when early in your career, because it's a really good if you have a good understanding and knowledge of allocation sheets and how they work, it will develop your overall knowledge of construction sites and the actual how long it takes to carry out these various activities. Concrete pour sheets as well. Obviously, whenever there is a concrete pour, you will have you'll obviously have a delivery docket. You'll also have there'll be a sum test for that, for that concrete delivered as well. So especially if there are queries around where concrete pours have occurred, then the pour sheets can be very, very useful for QSs also. Okay, so presenting, just include your narrative explaining the change against that in the contract intent. So the narrative is, what was the contract intent and what's changed basically. And again, I keep coming back to it. What was the contract intent? It must be clear that as to what your contract intent was, in order to give you the best possible chance of getting a variation. Has an instruction been received? If there has, obviously you should be referring to that. Make sure that the notice has been issued. Make sure that it's clear what the notice means, what it refers to. And ensure obviously that it gets sent on time. Quantities, look at that. The rates, including the bill quants, contract sum analysis, star rates, invoices, day worksheets, all as we were saying earlier in relation to the changes. You got to go back to the valuation rules and look at what has actually changed here. Can I use my bill rate, or do I go back to am I going back to basics, back to first principles and building up the rate based on your invoices, or am I recovering my labor through day worksheets as well? Obviously include drawings and specifications. Very important to again show the contract drawing, show the construction drawing, and demonstrate what change has actually occurred. And finally, presentation of your records is very important to, again, just to demonstrate what has changed and ultimately why it's a variation for which you should be entitled to additional payment. Okay, look, that's it. We're going to wrap up there. Thanks everyone for joining us. I think we've got a few questions which I'll pick up now with Julie. So yeah, look, thanks all for tuning in, and yeah, we'll see what good questions are raised in the Q&A.
Okay, we've got quite a few questions for you this morning, Conor, so I hope you've had your 3 shredded wheat and lots of oily fish. First one, if a contractor fails to perform and carry out the work regularly and diligently, can an employer then decide to omit work from the contract, whether it's JCT or NEC, in order to award it to another contractor?
Yeah, good question. I mean, it's an area that, a lot of contracts will actually state that, to say that, that the contractor, may omit work. But what's the key point to that question is that the contractor is failing to regularly and diligently to carry out the work. So if something has happened to say that the employer needs to substitute their labor in order to ensure that the project continues and that progress on site is not lost. Whereas what we were looking at in the case of Abbey Brickwork was, the contractor hadn't been, it wasn't a case that he wasn't progressing regularly and diligently. It was just a case that the employer was able to find an alternative contractor who could do the same work at better prices. So you got to look at the distinction between the two. If a contractor is failing to regularly and to approach the work regularly and diligently, then he's not going to get much sympathy to from employers, and it's going to be the case that an employer, and act for enough employers, if they need to supplement labor in order to ensure that progress is still maintained, then absolutely that can. And generally, you will see a lot of contracts do actually provide for that very reason and cause. But the key thing is that he has to have been failing to regularly and diligently progress. And just remember the distinction with that and Abbey Brickwork, where the developer just wanted to get another contractor in because he was cheaper. So there's a very important distinction between the two.
Okay, someone else is asking specifically on JCT form of contract. They're often asked for subcontractors' costs, and sometimes their subcontractors' costs and suppliers' costs to value a variation. This would suggest that the ability to value variations in accordance with JCT clauses is reducing, and the reliance is being placed on actual cost evidence, which is similar to NEC. Are you seeing evidence of this? Do you have any suggestions to address how valuing of variations can be enforced in accordance with JCT rules?
Yeah, good question. It's something that it certainly does happen a lot more, where you come across employers that that want all costs, just to prove. A lot of it is contractors needing it to prove it to PQSs. To clients' QSs, and I get that. That I can understand. They're doing their job. They're protecting the employer's interests, and that's absolutely what they need to do. The problem is that where does it go too far? And do you need invoices to prove each and every element of each and every additional cost that has to be paid out as a result of a variation? And NEC obviously has gone down this road because you're in a position where you have an activity schedule and you have such things as allowable and disallowable costs, and that has certainly caught on in the JCT assessment of variations. But I think you got to look at go back to your look at the starting point under the valuation rules under your JCT contract. Is it a change? So if the conditions have changed, you got to look at the elements. Are you looking for an uplift on your labor? Are you looking for an uplift on your material? Are you looking at an uplift perhaps on your plant? And you're going to have to go. You're going to have to give whatever information is reasonable to to demonstrate what information should be given over. You don't need to give over information for each and every item, particularly if it's already been covered in your bill of quantities rate. You were just focusing on the difference. You're just focusing on the commercial impact of the change, and you're going to have to give whatever information is reasonable to be able to demonstrate the difference. What allowance was in your contract, and then what are you actually looking for as a result of the change during the construction phase. It's a difficult area. It's a difficult area. You got to understand it clearly yourself to be able to to reason with contractors and with PQSs as to why such information is not necessary. But obviously, where the elements have changed and you need to demonstrate, then I'm afraid it is the case that you're going to have to give over potentially invoices or such other information, as is reasonable in the circumstances. It's a real hotbed for a QS, and it is a difficult area, but it's one that that must be grappled with and understood in order to have success.
Okay. We've got some other questions flooding in here. Is it okay to use internal, external cost data to price variations if you do not have a specific rate, i.e. bill of quants or the CSA has itemized works?
Internal. Yeah, the use of internal. I mean, you can't. I mean, look at you can use anything you want basically to substantiate variations. It's about what's credible here. I mean, the thing is, I mean, any generally internal information. I mean, unless it's been given by, perhaps you could have a separate department within a group of companies, perhaps, and often you see that perhaps with a plant company, that, a lot of companies will have their own internal plant. And I mean, if that is set up as a plant company, providing the rates are, reasonable and in line with the general market, then, I don't see any reason why you couldn't rely on, invoices or costs from that internal company, provided that they're reasonably in line with, with the general market. I don't have any issue with that. I mean, but again, you should be getting another kind of check on that from the market to prove that that the rate is reasonable and that is what you should be paid. So again, it comes back, this is, you got to use a commercial nous here to kind of understand, what I can use. Is this going to be scrutinized? Is it reasonable? Because if it's not reasonable, then it's, it's going to kind of, it's going to prolong the negotiations. It's going to waste a lot of time. And it's just going to affect the relationship. So I just think at all of these things, you got to be reasonable in what you're looking for here. And if you are putting forward internal cost information, again, if it's reasonable, in line with the market, I don't see any particular problem as to why it wouldn't be accepted.
Okay. Someone else is asking, where a subcontractor completes additional works without a formal instruction, and it's JCT DMB, where does the contractor sit with issuing retrospective instructions or paying these? Is there an argument that no formal instruction is no payment?
Yeah, it's a harsh line. I mean, and it's absolutely one that, a lot of employers will take, and it seems to be one that gets raised, late in the project, unfortunately, when when the contractor has carried out the work for which it feels it's entitled to a variation. Again, it's a case of being, for the contractor to be hot on his notices and on getting his variation pricing submitted sooner rather than later. I mean, if you are working under a DMB, you are carrying out what you believe to be additional work here, then you got to be submitting you got to be writing to your client to tell him, yeah, look, thanks for the instruction. We believe this is a variation under clause 5.2, and we'll submit pricing, or either please find attached my pricing, or we'll submit pricing for this variation in the coming days. Leaving items like that until the end, unfortunately, from my experience, doesn't bode well for the contractor. So you got to be careful with that and not let it get out of control. It's always better to have the conversation at the time that the variation is occurring as well. Because often, I mean, if a contractor goes ahead and solves the employer's problem, then the employer is less minded to, I'm not saying every employer, but a lot of employers are less minded to be favourable later on, and the goodwill built up by carrying out the additional work, unfortunately, gets forgotten pretty quickly. So contractors need to be careful, and they need to manage that process during the construction phase.
Okay.
Yeah.
Should a contract receive additional value for prelims that are already full-time on the project for the duration of the variation work? For example, if the client has already paid for the PM full-time on the project and a large variation is instructed, should the contractor receive additional value for the PM during this period?
Yeah, good question. It does come up quite a bit. So additional value, I mean, in the contractors, the contractors bill rates, providing he is using bill rates to value the variation. I mean, there will be an allowance in there for, for overhead and profit. So I mean, that will cater for such items like, overhead costs, head office costs, etc. So that should be focusing on here is, including for, additional time for a site manager or a site engineer. which may already have been allowed for in the prelims. And yeah, I mean, if they have a full-time allocation for a site engineer, then and that hasn't changed as a result, you got to look at the cause and effect here. You know, I mean, is the variation so significant that, you know, has it opened up an additional work phase, and you're now going to need an additional site foreman, site engineer, you know, chainman, every banksman, everything else that goes with it. I mean, it depends. You know, it won't. Again, you won't be surprised to hear solicitors say it depends on what the facts are, but it is very important to understand. It comes back to cause and effect, because it depends, and the severity of the, you know, of the variation. As they say, if the, you know, if the variation is so significant that it results in a delay to the project, then, you know, under the standard JCT, the standard JCT position would be that they'd be entitled to an extension of time, and then they'd attach the loss and expense, which would be the prolonged prelim costs on site. You'd also need to look in there as to, you know, as to whether you're looking at a prelim thickening as a result of these variations. Look, that can be picked up in the variation. I actually think it's better for that to be picked up in loss and expense, because it's very complicated with prelims if you keep adding in like price of a site manager, price of a site foreman into the variations. It's actually it can be very difficult to establish just how much like additional money has been allowed for such elements in each additional variation. I think it's easier, and from my own experience doing it, I'd always thought it was easier to do that, you know, in your loss and expense, where you can absolutely link it to the variations. Because if you look at your loss and expense ground, you know, variation is a ground, you know, for loss and expense, but you got to look at what, you know, what you got to be careful. You got to be very specific about what it is you're looking for. If the variation has occurred, you need additional prelims on site, then go for that under your loss and expense application, again, all of which is under the contract. This is not a claim. This is all linked, and this is how loss and expense variations work hand in hand, and is the intention of the JCT drafting, and is absolutely how it should be used as well.
Okay. Someone else is asking, what is the position generally when a contractor is claiming for a variation where works were supposedly excluded from the contract, as the contractor claims, but this is not explicit in the contract as to whether the works were excluded?
So the contractor is on site. He's carried out work that was excluded from his package, is it?
Yeah, he's claiming for a variation where works were supposedly excluded from the contract. But
right.
This is
Okay.
not explicit in the contract.
It's not been expressed in the contract. I'm trying to think of an example where that, you know, where that would happen. I mean, you know, contractor should be working to his brief, working to his scope, working to his pricing. I mean, I've been trying to say that if a contractor goes, you know, it's almost like a contractor going off in a frolic of his own and carrying out work which he's not supposed to. You know, the reason why we have contracts is that we, you know, it's clear what it is the contractor is required to do. And it's certainly not within the, you know, the contractor's remit to unilaterally decide whether excluded work should be completed or not. I'm afraid if the contractor strays into such territory that he's going to struggle to get his to pick this up as a variation. Unless it was the case that, you know, other contractors were going to come in, but I mean, by you know, potentially by doing that, you know, the contractor could have denied the employer the opportunity to have that excluded work carried out by others at better rates or prices. Yeah. You know, it's almost the reverse position of, you know, the omission situation we had in Abbey Abbey Developments. So yeah, contractors need to be careful, you know, stick to the contract, stick to the brief, you know, do what they're actually given authority to do under the contract. If you're straying outside that, you got to be raising it in emails or correspondence to see whether this actually should occur, because I wouldn't have much sympathy for a contractor who would go ahead and just decide unilaterally to carry out such excluded work. shouldn't operate on that basis.
Right. So frolicking is strictly forbidden.
No frolicking.
I don't think I've ever heard that used in that word in conjunction with construction.
It's very common in adjudication circles in relation to adjudicators. It applies equally here with contractors carried out excluded works. You shouldn't do it. Be very careful with it.
No frolicking.
No frolicking.
Forget that.
Yeah.
Okay, someone else is asking, what is the position in terms of variations and when cost information needs to be provided by a contractor for these? Is there anything within JCTs that suggests that variations must be agreed or unagreed by a certain time?
Yeah, standard unamended JCT says there's no time period for variations. Obviously, you've got to get them within a reasonable time, which is so. Yeah, you just got to be able to pick it up, quicker. And again, when I'm saying this for the benefit of the contractor. The sooner he's able to get this information in front of his client, the sooner the client is able to make an assessment, decide whether it's a variation, and reach an agreement. So from a contractor's point of view, you should be getting the information in, as soon as possible, really, because without it, the PQS or the employer is going to struggle to properly assess it, and I don't blame employers or PQSs for not agreeing variations for all of the information has been provided. That's absolutely within their remit. I mean, and part of their own their cost control, their management of the project commercially. They need that information to do it. So I think from a contractor's point of view, you should be getting it in as soon as you possibly can, really, in order to obviously get agreement that it is variation, and then obviously the next step is to agree what additional value should be given for that variation. If you don't do that, you just run the risk of waiting until the end and having a whole buildup of the variation account. Which just ends up being, you get a deal is done at the end potentially, but often, and in my experience where that has happened, that deal is generally not in favor of the contract. So if you want to have better success with your variations, you got to be vigilant with giving the notice and giving the cost information that proves the variation. You do that as soon as you possibly can, then you'll have a better recovery in your variations, which gives you a better chance of making some money on your project, which is what is what we're there for.
Okay. Someone else has got a question on temporary works. If the temporary works for which the contractor has taken risk on results in a change required to the permanent works, is this deemed to be a variation?
Yeah, good question. So the temporary works. Yeah, I mean, it comes down. I mean, I think that if the contractor, he can't cause his own, he can't create his own variations essentially. The temporary works will be, typically in JCT there'll be a contractor's design portion. Now, that contractor's design must be, has to be carried out, bearing in mind the permanent works. I mean, it can't be the case that the contractor can design a very, I suppose, skimpy temporary works system in order to gain a commercial advantage, and then. But ultimately, which has a knock-on effect of costing the employer additional money. It's a good question. It would bear into the specifics, and if they want to send an email on that, it's one I can advise on more carefully. But it'll come down to the degree of the why the temporary works. Was it suitable for the for the contract at the time it was proposed? And also, is it the case that the additional permanent works can be completely linked or to that temporary works? Often, the temporary works might be one of a few reasons, and I can see why an employer might want to kick back on the temporary works, but very often the change may have occurred because the design elsewhere was developed and the building ended up being heavier, or other changes occurred. So again, back to your cause and effect. Is it clear that purely as a result of that temporary works, the rest of the building, has the permanent solution essentially has had to be developed at a greater cost to the employer? It comes back to cause and effect, and look, absolutely happy to take a question on that if they want to send it in specifically, Julie, because it's quite an interesting one.
Okay, no problem. I'll put the two of you in touch afterwards.
Okay.
If a contractor submits a quote after the completion date for works requested by the employer on a project where the contractor is still on site after the completion date, does the contractor have grounds for reducing possible LADs?
Contracts. Sorry, I'm just reading the question here again. Actual completion. Yeah, I mean, it's a good question. I mean, arguably, if the completion date has occurred, I presume that you've been issued with your practical completion certificate, which is obviously the key requirement to any potential LADs. And if you go back to, if the contractor goes back to site and carries out additional work, then he should be entitled to the time that goes, to the reasonable time that goes with allowing the performance of that additional work. It wouldn't be fair that you bring the contractor back, get him to submit a variation, and then hit him for LADs, because somehow he has been on site beyond the original completion date. Arguably this is actually a separate contract beyond outside of the original contract that has been agreed, which will now actually be in its in its defects liability phase post practical completion. So absolutely, the contractor will have grounds for reducing possible LADs. You should be the contractor should be agreeing a time frame in which to carry out the work, allowing such prelims as are necessary to carry out the work in that time. And only in the only in the event that he goes beyond that time could there be any discussion about LADs. The contractor needs to be careful with that, though. He needs to clarify no LADs. And even if he says no LADs, even if he goes beyond his completion date, as we know, the position, if there are no LADs, is general damages. So yeah, if he does go beyond the time frame for the additional work, then then he could be open to those costs. So he's got to be careful, but he's just got to clarify his risk again and going back to carry out the additional work.
Okay. That's great, thank you. We had an awful lot of questions for you to get there through, and some random frolicking. So that was always an interesting result. So thank you very much, Conor, for your time this morning and the information. And thank you everyone for joining us. As you can see on the screen there, our next ones are tomorrow, and our last one for the year will be next Thursday at 4 p.m, which is a property roundup of the impact of COVID to date. If anyone would like places on either of these, please email us seminars@silverllp.com. In the meantime, we'll say to everyone, have a great day, travel safely, those of you that are going into work, and we'll see you all again soon. Thanks, Conor. Thanks, everyone.
Thanks, Julie. Thanks, everyone. Bye.